The clock had barely passed 6:223 this morning when something extraordinary unfolded. Federal law enforcement moved in on not one, not two, but three separate properties tied to the same individual. And if this sounds like just another headline that will vanish by tomorrow, you need to understand how federal investigations actually work. When I say federal agents arrived, I am not talking about a routine knock on the door or a casual request for cooperation. This was a coordinated operation involving multiple teams, forensic specialists, and legal personnel from units that typically step in only when national security is at stake. After 3 decades inside the federal prosecution system, handling cases ranging from organized crime to public corruption, I can tell you this with confidence: operations like this do not happen because someone filed a complaint. They happen because investigators have assembled enough evidence to persuade a federal magistrate that there is probable cause to believe criminal evidence is inside those locations. So here's what I'm going to do. I'm going to break down what happened at each site, explain the legal basis for the searches, and show why what agents reportedly found is not just a records dispute or a bureaucratic headache. If accurate, it points to potential violations of laws designed to protect the nation's most sensitive defense secrets. Violations that can carry years, even decades, in prison. That is the key difference between this development and every other twist in this story. Federal magistrates do not approve search warrants based on guesswork. The warrant application had to meet a strict legal standard backed by documented facts, credible testimony, and evidence suggesting that national defense information was being unlawfully retained and possibly concealed from authorities. I'll be following this case through the justice system by focusing on evidence, court filings, and legal procedure, not partisan talking points. If you want analysis grounded in documents instead of social media speculation, stay with me. Let's walk through what happened at each location because the details matter. The first site agents searched was a private estate in Palm Beach. According to the timeline, the operation began at 6:23 a.m. Eastern. 17 federal agents arrived, along with 3 forensic document specialists and 2 prosecutors from a Justice Department unit that handles national security matters. Their presence alone signals the seriousness of what investigators believed they were dealing with. That division does not get involved in simple record-keeping disputes. Its work centers on classified intelligence, espionage, and threats to national security. The warrant reportedly authorized agents to search any area on the property where documents could be hidden, including bedrooms, offices, storage rooms, secure areas, and even vehicles on the premises. The search lasted roughly 9 hours. When agents left at 3047 that afternoon, they had removed 33 containers of material, 18 folders marked top secret, and 3 digital storage devices containing electronic files. Let's pause there. 18 folders marked top secret is not a small detail. That is the highest standard classification level in routine use, reserved for information whose unauthorized disclosure could cause exceptionally grave damage to national security. In practical terms, that can mean compromised intelligence operations, exposed sources and methods, or direct risk to lives. The second location was a storage facility in Northern Virginia, one that had not previously been publicly identified. Unsealed legal documents reportedly show that investigators learned about it from a cooperating witness, someone with first-hand knowledge who told federal agents that materials had been moved there to keep them away from investigators. That search began at 7:15 a.m. Nimblest. Agents recovered 12 more containers holding classified material. Several were reportedly marked as sensitive compartmented information, or SCI. That category is subject to some of the tightest controls in the U.S. intelligence system. It is not supposed to be stored in a private residence, a standard office, or a commercial storage facility. It is meant to be handled only in specially secured environments. The third site was a private office in New York. Agents arrived there at 8:00 a.m. and reportedly found 7 more containers holding classified documents tied to foreign intelligence collection. According to the account, some of those records included information related to human intelligence assets, meaning people who provide intelligence to the United States overseas. If that kind of information is mishandled or exposed, the danger is not abstract. It can become life-threatening for people in the field. One question many people will ask is whether these materials had been declassified. Investigators, according to this account, say they had not. There was allegedly no documented paper trail, no formal memorandum, and no evidence of a completed declassification process. And even setting classification aside for a moment, presidential records do not belong to a former officeholder personally. By law, They belong to the National Archives. Removing and retaining them can still create serious legal exposure. The central legal issue here is not simply classification status. It is the willful retention of national defense information, especially after repeated efforts by the government to recover it. So ask yourself this. If federal agents allegedly found top-secret materials across 3 different locations after months of requests, subpoenas, and sworn representations that everything had been returned, does that look like a mistake? Or does it suggest deliberate retention? Now let's look at the timeline, because the sequence of events is crucial. In January of last year, the National Archives formally requested the return of classified materials. In February, 15 containers were returned, but they reportedly contained records with classification markings, which triggered further concern and drew in the FBI. In March, the FBI sought confirmation that all remaining materials had been turned over. In April, a witness came forward claiming that documents were still being held. In May, a grand jury issued a subpoena demanding any remaining records. In June, 4 more containers were returned, along with a sworn certification stating that no other materials remained. But according to investigators, that certification was false. Federal authorities reportedly had witness statements, surveillance footage showing containers being moved, and electronic communications discussing the relocation or concealment of documents. Prosecutors took that evidence to a federal magistrate who found probable cause to issue search warrants. That is why agents were at those properties at dawn. So what does the law actually say? The main statute likely at issue is 18 U.S. Code Section 793, part of the Espionage Act. Despite the name, this provision does not require proof of spying for a foreign government. It criminalizes the willful retention of national defense information and the failure to deliver it to the proper U.S. official upon demand. To prove a case under that statute, prosecutors generally need to establish 3 things. First, that the documents contain national defense information. If the materials included top-secret or SCI records involving military capabilities, intelligence sources, or defense programs, that element would likely be central to the government's case. Second, that the person had unauthorized possession of those materials. When someone leaves office, they do not have personal authority to store government national defense records at private properties or commercial facilities. Third, that the retention was willful. That means not accidental, not negligent, but intentional, with knowledge that the conduct was improper. And this is where the reported timeline becomes especially important. Multiple requests were made. A grand jury issued a subpoena. A sworn statement allegedly said everything had been returned. Yet investigators then reportedly found dozens more containers at 3 separate sites. If proven, that sequence would be powerful evidence of willfulness. But that may not be the end of it. If the evidence shows that documents were not only kept but actively hidden, moved, or concealed from investigators, prosecutors could also look at obstruction of justice. That is a separate and often very serious federal offense. Alleged staff communications about moving boxes, the transfer of materials after a subpoena, and a false sworn certification could all become part of an obstruction case if the government believes those acts were deliberate. The penalties here can be severe. Willful retention of national defense information can carry up to 10 years in prison per count. Obstruction can carry up to 20 years, depending on the statute used. False statements to federal investigators can add additional exposure. If prosecutors choose to charge document by document or combine retention charges with obstruction counts, the theoretical sentencing exposure can quickly rise into decades. Now, let's address the defenses people are likely to raise. First, some will argue this was politically motivated. But search warrants at this level require multiple layers of approval, including senior Justice Department review and authorization by a federal magistrate. That does not prove guilt, but it does mean this was not a casual or impulsive decision. Second, others will say the documents were declassified. If there's no documentary evidence of a valid declassification process, that defense becomes much harder to sustain. And again, even declassification would not automatically convert presidential records into personal property. Third, some will frame this as a records management dispute, but if the government can prove concealment, false certifications, or movement of records after a subpoena, then the case shifts far beyond paperwork negligence and into potential criminal obstruction. Fourth, supporters may point to other officials who mishandled classified information, but federal law distinguishes between inadvertent mishandling and willful retention coupled with obstruction. That distinction is likely to be at the heart of any charging decision. So what happens next? Right now, investigators would be cataloging everything seized, conducting forensic review, and interviewing witnesses who can identify, authenticate, and explain the materials. Prosecutors would then decide what evidence to present to a grand jury. The grand jury could hear from FBI agents, archival officials, intelligence specialists, and witnesses involved in the movement or storage of the documents. If the grand jury returns an indictment, the case becomes a formal criminal prosecution. The defendant would appear in court for arraignment, hear the charges, and enter a plea. After that, the case would move into the standard federal criminal process: motions, discovery disputes, classified evidence issues, and eventually, potentially, trial. Based solely on the narrative laid out here, the government's case would appear to rest on two pillars: the sensitivity of the documents and the evidence of intentional concealment. If those two pillars hold up in court, the legal exposure could be very serious. But beyond any single person, this case matters for a larger reason. The classification system exists to protect information whose disclosure could damage the country. When the government labels something top secret, it is saying that unauthorized exposure could create exceptionally grave harm, not theoretical embarrassment, but real-world consequences: compromised operations, broken intelligence channels, damaged alliances, even loss of life. That is why these rules are taken so seriously across the military, intelligence community, and federal service. Countless people with security clearances understand that mishandling classified material can end a career and, in some cases, lead to prison. The law is supposed to apply the same way whether the person involved is junior personnel, senior officials, or a former president. That is what equal justice under law is supposed to mean. In the end, evidence will determine what comes next. The grand jury will decide whether charges are warranted. If charges are brought, a jury will decide guilt or innocence. That is how the system is meant to work. I'll continue following every major development in this case, focusing on legal filings, evidence, and procedure rather than partisan noise. And based on what investigators reportedly discovered in these searches, the real question now is this: do you believe criminal charges are inevitable, or do you think the defense still has a path out?